Well, this week we are talking with Mahoning County Prosecutor Paul Gaines for our in-depth segment.
Today, we take a look at what happens when prosecutors get involved in an investigation and how they take a case to court. Here's WKBN Community Affairs Director Dee Crawford.
When an individual comes again into the prosecutor's office, regardless of the municipality, and charges are brought, what happens next? The individual is formally charged?
Yes, and well, there's two ways to charge on a felony. Misdemeanors all go through the municipal court, and if you want to keep it just strictly to Youngstown, we can do that. Or they can directly present it. They can bring the file over to us, and we can directly present it to the grand jury. We will directly present cases that are where the witnesses are reluctant to come forward to testify. They don't want to testify at a preliminary hearing. And we do a lot of direct presentments, more than we did when I took office.
The issue then can also be that you don't have witnesses who are willing to come forward to gather enough evidence to bring charges?
Well, without witnesses, we cannot convict. And we need the witnesses to come forward. Obviously, witnesses can be fearful. They don't want to be bothered. They prefer to go on with their lives. But unfortunately, when they take that stance, then the criminals win, and they continue to remain at large and terrify the community. So we try to gather as much evidence as we can, because nobody wants these people on the streets, especially the police, and certainly my lawyers don't want them on the streets.
Talk about plea bargaining. An individual can come before the courts and plead to a lesser charge. How does that process work, and is that a deterrent, or have you seen where this individual is back on the streets after a short period of sentence?
Well, it depends, and you can't, not all plea bargains result in short periods of sentencing. But plea bargaining is an essential element of the criminal justice system. Nationwide, and I'm talking both state and federal courts, less than 10% of the cases go to trial. 90% of them result in pleas pursuant to plea agreements. And of course, Rule 11 allows for plea agreements. Excuse me. So it's an essential element of it, and there are, on rare occasions, we won't offer a plea agreement to a particular defendant, but in those cases, the evidence has to be very strong. But most plea agreements result from here's what happened. The defense lawyer is going to assess the case, the prosecutor is going to assess the case. We sit down and we look at risk of losing the case, getting a not guilty verdict, as opposed to the risk of obviously winning the case, and that's the way the defense lawyer looks at it. So in order to determine whether or not to plead the case out, we look at the evidence primarily. We can look. Go ahead. So
that's, again, a decision that is reached in the best interest of at least removing that individual from the street and finding them guilty.
Well, on other cases, there are times where people may have mental health issues that we try to address. So they may plead to a charge, be placed on a period of probation, but then they're ordered to get the mental health counseling. So there is, you know, if there are people that need help, we would try to help them.
I want to thank you for that. And tomorrow we're going to talk about juveniles and the issue of recidivism and how that affects cases coming into the court. I'm Dee Crawford, Community Affairs Director, WKBN.